The Rock sat perfectly still as Attorney General Harrison delivered what seemed like a devastating legal challenge in front of the packed Department of Justice hearing room. Reporters assumed they were about to witness a celebrity being humiliated by America's top legal mind. But Dwayne Johnson had prepared for this moment for years, and what happened next would transform him from action hero to constitutional champion in the most unexpected legal showdown of the decade. Before we dive into this extraordinary confrontation, make sure to subscribe to our channel and hit the notification bell so you never miss these incredible stories of hidden genius and unexpected triumph. The ornate conference room on the 5th floor of the Robert F. Kennedy Department of Justice building had never hosted anything quite like this. Floor-to-ceiling windows overlooked Pennsylvania Avenue, while portraits of former attorneys general watched silently from mahogany-paneled walls. At the head of the massive oak table sat Attorney General Michael Harrison, a Harvard Law graduate with 30 years of prosecutorial experience and a reputation for dismantling opposition arguments with surgical precision. Across from him, looking surprisingly composed in his tailored Navy suit, sat Dwayne "The Rock" Johnson. The former wrestler turned Hollywood superstar had arrived that morning to testify in a federal hearing regarding employment practices in the entertainment industry. What most people in the room didn't know was that this wasn't just another celebrity making token appearances at government hearings. The case centered on Johnson's production company, $7 Productions, which had been accused by the Department of Labor of violating federal employment regulations during the filming of his latest action franchise. The allegations involved worker classification, overtime compensation, and safety protocols that could result in millions in fines and potentially shut down Johnson's entire production empire. Attorney General Harrison had personally taken over the case, seeing it as an opportunity to demonstrate that no one, regardless of fame or fortune, was above federal law. He entered the hearing room that morning confident that he would make quick work of what he assumed was just another entitled celebrity trying to avoid responsibility. Johnson's legal team, led by white shoe firm partners from Williams and Amp. Connolly, had advised him to offer settlement and avoid the publicity nightmare of a prolonged legal battle. The standard playbook for celebrity legal troubles involved admitting no wrongdoing, paying substantial fines, and moving on quietly. But Johnson had rejected their advice, insisting on fighting the charges personally. "Mr. Johnson," Harrison began, his voice carrying the authority of someone accustomed to courtrooms and congressional hearings. "You've chosen to appear here personally rather than allowing your attorneys to represent you. That's certainly your right, but I want to ensure you understand the serious nature of these federal violations." The room was packed with journalists, legal analysts, and Department of Justice officials. C-SPAN cameras captured every moment for broadcast, while reporters from major networks prepared to cover what they expected would be a straightforward government victory over Hollywood excess. Johnson leaned slightly toward the microphone. "I understand completely, Mr. Attorney General. I'm here because I believe these charges are not only unfounded, but represent a fundamental misunderstanding of both the facts and the law." Harrison's eyebrows rose slightly. In his experience, celebrities typically offered contrite apologies and wrote large checks rather than challenging federal attorneys on legal grounds. "Mr. Johnson, with respect, employment law is extremely complex. These regulations exist to protect workers from exploitation, something I'm sure you support in principle." "I absolutely support worker protection," Johnson replied evenly. "That's precisely why I'm here to demonstrate that my company has not only complied with all applicable regulations, but has exceeded federal requirements in every measurable category." The confidence in Johnson's voice caught Harrison off guard. Most defendants, particularly those without legal training, appeared nervous when facing federal charges. Johnson seemed almost prepared. Harrison decided to establish dominance early. "Mr. Johnson, you've built an impressive entertainment career, but federal employment law isn't a movie script. The Department of Labor's investigation revealed multiple violations of the Fair Labor Standards Act, OSHA regulations, and union contract requirements. These aren't creative interpretations, they're black and white legal violations." Johnson nodded respectfully. "Mr. Attorney General, I appreciate your concern for worker rights. However, I believe the department's investigation relied on outdated interpretations of employment classification that don't account for evolving industry practices or recent federal court precedents. Several attorneys in the room exchanged glances. Johnson wasn't speaking like a typical celebrity defendant. His language was precise, measured, and surprisingly sophisticated. Harrison pressed forward. Mr. Johnson, the Fair Labor Standards Act is quite clear about overtime compensation requirements. Your production company failed to pay time-and-a-half wages to numerous crew members who worked more than 40 hours per week. Actually, Mr. Attorney General, Johnson replied, opening a thick folder he had brought with him. The crew members in question were classified as independent contractors under the economic reality test established by the Supreme Court's decision in Nationwide Mutual Insurance Company v. Darden. Their contracts explicitly outline project-based compensation rather than hourly wages, which places them outside FLSA overtime requirements. The room fell silent. Johnson had just cited a Supreme Court case from memory and applied it directly to the charges against him. Harrison, who had expected to spend the morning explaining basic legal concepts to a confused actor, found himself facing someone who appeared to understand employment law. That's an interesting interpretation, Harrison said, clearly reassessing his approach. However, the Department of Labor's classification guidelines are advisory rather than binding. Johnson interrupted gently. As the D.C. Circuit held an Association of American Railroads versus Department of Transportation, agency guidance documents cannot create new legal obligations beyond what Congress has specifically authorized in the underlying statute. Reporters in the room began typing frantically. Whatever they had expected from this hearing, it wasn't a detailed discussion of federal jurisprudence led by The Rock. Harrison leaned forward, his tone becoming more aggressive. Mr. Johnson, regardless of your research, the fact remains that multiple workers have filed complaints alleging unsafe working conditions on your film sets. Johnson's expression remained calm. Mr. Attorney General, I take worker safety extremely seriously. Every production facility operated by $7 Productions maintains safety protocols that exceed OSHA requirements by an average of 37%. He turned to a specific page in his folder. More importantly, the complaints you're referencing were filed by individuals who never actually worked on our productions. As documented in Exhibit C of our response filing, 3 of the 5 complainants were employees of subcontractor companies with no direct relationship to $7 Productions. Harrison's chief deputy leaned over and whispered something urgent in his ear. The Attorney General's expression tightened as he realized Johnson wasn't just prepared, he was winning. Mr. Johnson, Harrison said, his voice taking on an edge, you seem to have done considerable research. But legal research isn't the same as legal understanding. These federal regulations exist because workers need protection from employers who prioritize profits over people. Johnson nodded seriously. I completely agree, Mr. Attorney General. That's why $7 Productions has voluntarily implemented worker protection standards that go far beyond federal minimums. We provide comprehensive health insurance, profit-sharing bonuses, and safety training programs that have resulted in 0 serious injuries across 47 separate productions. He paused, then continued with quiet intensity. But more fundamentally, these charges appear to violate the due process protections guaranteed by the Fifth Amendment's Due Process Clause. The department initiated this investigation without probable cause, relied on complaints from non-employees, and sought penalties grossly disproportionate to any alleged violations. The transformation in the room was palpable. Johnson had shifted from defendant to constitutional advocate, and his command of legal doctrine was undeniable. Harrison, recognizing he was facing an unexpectedly formidable opponent, decided to challenge Johnson's credentials directly. Mr. Johnson, your knowledge of case law is impressive for someone without formal legal training. However, constitutional law requires more than internet research and consultant briefings. Johnson met Harrison's gaze directly. You're absolutely right, Mr. Attorney General. Constitutional law requires rigorous study, careful analysis, and deep understanding of legal precedent. He reached into his briefcase and removed a bound document. That's why I spent the last 5 years earning my Juris Doctor degree from Georgetown University Law Center, graduating magna cum laude with a concentration in constitutional law and employment regulations. The hearing room erupted. Reporters began talking over each other, photographers snapped pictures, and legal analysts scrambled to process this revelation. The Rock, Hollywood action star, former professional wrestler, social media phenomenon, was a Georgetown law graduate. Harrison sat back in his chair, visibly stunned. "I was not aware of your legal education, Mr. Johnson. I kept it private," Johnson replied simply. "I wanted to earn my degree based on merit, not celebrity. My professors and fellow students knew me as Dwayne Johnson, law student, not The Rock, movie star." Johnson opened his law degree and placed it on the table. "I attended evening classes while filming during the day, spent summers clerking for federal judges, and wrote my law review article on the intersection of employment law and constitutional due process protections." The silence in the room was profound. Harrison, who had entered the hearing expecting to embarrass a celebrity, now faced a Harvard-educated prosecutor's worst nightmare, an opponent who knew the law as well as he did. Furthermore, Johnson continued, "I believe this entire proceeding violates the constitutional principles established in Matthews v. Eldridge regarding due process in administrative hearings. The department has failed to provide adequate notice of the specific violations alleged, has not allowed meaningful opportunity to respond to evidence, and has predetermined outcomes before conducting any substantive review." Johnson turned to another section of his materials. As the Supreme Court held in Goldberg v. Kelly, when government action threatens significant deprivation of property or liberty interests, procedural due process requires fair hearings with adequate safeguards. The department's investigation violated every one of these constitutional requirements. Harrison's deputy was now frantically reviewing documents, clearly trying to verify Johnson's claims. The Attorney General himself appeared to be reconsidering the entire case. "Mr. Johnson," Harrison said carefully, "these are serious constitutional allegations. Are you claiming that the Department of Justice has violated your constitutional rights?" "I'm not making claims, Mr. Attorney General. I'm stating facts supported by Supreme Court precedent and documented evidence." Johnson's voice remained respectful but firm. The Due Process Clause of the Fifth Amendment requires that government agencies follow established procedures when seeking to impose penalties on private citizens. This investigation has failed to meet those constitutional standards. Johnson reached for another document. Additionally, the penalties sought by the department appear to violate the excessive fines clause of the Eighth Amendment as interpreted in United States v. Bajikajian. The proposed fines of $12 million are grossly disproportionate to any actual harm caused and appear designed to punish rather than remediate. The legal precision of Johnson's argument was remarkable. He wasn't just citing cases, he was building a comprehensive constitutional defense that addressed every aspect of the government's case. Harrison made one final attempt to regain control. "Mr. Johnson, constitutional arguments aside, the fact remains that your company's practices may have harmed workers. Don't you think some accountability is appropriate?" Johnson's expression grew more serious. "Mr. Attorney General, accountability is exactly what I'm advocating. True accountability requires accurate facts, fair procedures, and proportionate responses. This investigation has provided none of those elements." He stood and walked to a whiteboard that had been set up for presentations. "Let me walk through the actual evidence regarding $7 Productions' employment practices." For the next 20 minutes, Johnson methodically dismantled every allegation made by the Department of Labor. He presented documented evidence of superior wage practices, comprehensive safety protocols, and voluntary worker protection programs that exceeded federal requirements. His presentation was precise, well-organized, and devastatingly effective. In conclusion, Johnson said, returning to his seat, $7 Productions has not violated any federal employment regulations. More importantly, this investigation itself violates constitutional due process protections that are fundamental to our legal system. Johnson looked directly at Harrison. Mr. Attorney General, I have tremendous respect for your office and the important work of the Department of Justice. But when government power is exercised without constitutional authority, it threatens the rights of all Americans, not just Hollywood actors. The hearing room remained silent as Harrison absorbed the complete reversal of his expectations. He had entered the room confident of an easy victory over an unprepared celebrity. Instead, he faced a constitutional scholar who had systematically exposed the weaknesses in the government's case. Mr. Johnson, Harrison said finally, your legal analysis is considerably more sophisticated than I anticipated. The department will need to review the constitutional questions you've raised. Johnson nodded respectfully. I appreciate that, Mr. Attorney General. I'm confident that when the department conducts a fair review based on accurate facts and constitutional requirements, they'll find that $7 Productions has been a model employer that prioritizes worker rights and safety. As the hearing concluded, reporters rushed to file stories about the most unexpected legal confrontation in recent memory. The Rock had not only defended himself successfully against federal charges, but had done so with a level of legal expertise that impressed even veteran Department of Justice attorneys. 3 weeks later, the Department of Justice quietly dropped all charges against $7 Productions, acknowledging that their investigation had failed to establish violations of federal employment law. More significantly, the case prompted an internal review of DOL investigation procedures to ensure compliance with constitutional due process requirements. For Johnson, the victory represented more than just avoiding fines and sanctions. He had demonstrated that preparation, knowledge, and respect for constitutional principles could triumph over institutional power and preconceived assumptions. In interviews following the hearing, Johnson was characteristically humble about his legal education and courtroom performance. The law belongs to everyone, he said. When we understand our rights and responsibilities, we can hold our institutions accountable while working together to solve real problems. The case became a landmark example of how celebrity status and legal expertise could combine to advance important constitutional principles. Law schools began using Johnson's arguments as examples of effective due process advocacy, while employment law practitioners studied his strategic approach to challenging federal regulations. Perhaps most importantly, the confrontation demonstrated that in America's legal system, thorough preparation and constitutional knowledge could still overcome institutional bias and predetermined assumptions. The Rock had entered that hearing room as a defendant, but emerged as a constitutional champion who had reminded everyone present that in America, the law truly applies equally to all citizens. The transformation was complete. Dwayne Johnson had evolved from action hero to legal scholar, proving that sometimes the most powerful victories come not from physical strength, but from intellectual preparation and unwavering commitment to constitutional principle. And it all began because one man refused to be intimidated and chose, instead, to master the law that governs us all.